Some of this chapter is a review, and you've already had this some of these topics. There are a couple I want to just brush back over, and then there's some new information as well. One of the things that you've learned a lot about has been the Nurse Practice Act, and it's one of the single most important pieces of legislation that we have in nursing, because it affects all aspects or all facets of nursing practice. The act is actually a law within a state or either U.S. territory, and the state boards of nursing cannot grant exceptions, waive the act's provisions, or even expand practice outside of the act's specific provisions. And also, too, please note that there are three categories underneath this, and this is your LPNs, your RNs, and advanced practice nurses all fall underneath this umbrella term. The main purpose of the state boards of nursing, remember, is to ensure enforcement of this act, regulating practitioners who come under its provisions, and preventing individuals not addressed within the act from practicing nursing, such as someone off the street pretending to be a nurse. And it also helps to protect the public, ensures that those who present themselves as nurses are licensed to practice in the state. As we start gathering information and getting ready for you to take your boards and start giving you out NCLEX information, one of the things you're going to come across is the MultiState Licensure. And this is when multiple states now are a part of a license compact. This allows nurses to hold a license in their state of residence and provides nursing care to citizens to adjoining states. So if you live in the state of Virginia, you can go over to Maryland and practice. Say you're a travel nurse and you live in one state, but you do travel across the state lines to practice, then you are still underneath that compact of that state. You have to find out which states are part of that, though. Generally, it's seen in conjunction with telenursing and also in the use of telecommunications technology that we're seeing more and more of. It also may be seen in conjunction with nurses who live, again, as I said, close to borders, or who travel to adjoining states for employment. I know some of this is a review, but we can never hear enough of it, and this is negligence and malpractice. And negligence is when conduct that is lacking in care and typically concerns non-professionals. When you have malpractice, this is referred as a professional negligence. It concerns professional actions and is the failure of a person with professional education and skills to act in a reasonable and prudent manner. Some of the common causes of malpractice or negligence among nurses can be failure to follow standards of care, communicate appropriately, assess and monitor patients, and act as a patient advocate. Both of these result either from commission or omission, and both are non-intentional. So you have to remember that, non-intentional. Though the patient suffers some harm, there was never an intent for this actually to happen. So let's say you walked out of the room, forgot to put the bed down, the patient tries to get up and they fall. You didn't mean for that to happen. It was not intentional, but you were negligent. These are actually not on the next slides, but these we have gone over before, so make sure you're always aware of these. The elements of malpractice, all of these have to be proven. This is duty owed to the patient. Breach of this duty is owed the patient. Foreseeability, causation, injury, and damages. So what is it that the nurse manager can do to help prevent malpractice lawsuits? The nurse managers actually must know the applicable standards of care and ensure that all the employees of that institution either meet or exceed them. Update standards as needed, or ensure that the appropriate committee reviews and revises outdated standards. Means of ensuring that employees meet the standards can be performing or reviewing all performance evaluations for evidence of standards of care and make sure that they're met. reviewing randomly selected patient charts for standards of care and documentation. Also, inquiring of employees. What constitutes standards of care and appropriate references for standards of care within that institution. Liability, there's different types. You have personal liability. This defines each person's responsibility and accountability for individual actions or omissions. Even if others can be shown to be liable for a patient injury, each individual retains personal accountability for his or her actions. The law, though, sometimes allows other parties to be liable for certain causes of negligence. This can be known as vicarious or substituted liability. It makes employers accountable for the negligence of their employees. You also have corporate liability. This is a little bit newer that we're seeing more in lawsuits, and essentially it holds that the institution has the responsibility and accountability for maintaining an environment that ensures quality healthcare delivery for all the consumers. So corporate liability issues include negligent hiring and firing issues, failure to maintain safety in the physical environment, lack of qualified, competent, and adequate staffing. Here's a few more concerns that are with malpractice for nurse managers, and this includes assignment and delegation, supervision, duty to orient, educate, and evaluate, failure to warn, staffing issues, and protective and reporting laws. And we'll go over some of these here in just a second. So here the nurse manager retains personal liability for reasonable exercise of assignment, delegation, and supervision activities. The failure to assign, delegate, and supervise within acceptable standards of professional nursing practice may constitute malpractice. Delegation involves transfer of responsibility for the performance of tasks and skills without the transfer of accountability to or for the ultimate outcome. This is most likely encountered when working with unlicensed assistive personnel. Your assignment typically occurs between professional staff members, such as when the nurse manager assigns patient care responsibility to other professional nurses working in the same unit of the institution or community healthcare setting. In other words, they're not prepared for that type of patient. They're not educated on the needs of that patient or the types of medicines or care that they need. The level of accountability for the nurse manager who assigns as opposed to delegates is fairly obvious, although there can be some accountability in both of these instances. However, if it can be shown that a nurse manager assigned or delegated tasks appropriately, had no reason to believe that the nurse to whoever these tasks were assigned to or delegated to was not competent to perform the task, the nurse manager potentially has either no or minimal personal responsibility. The opposite is also true. If it can be shown that the nurse manager was aware of incompetence in a given employee, or that the assigned or delegated task was outside the employee's capabilities, the nurse manager becomes liable for the subsequent injury to a patient. Now here's where some of you are going to want to pay attention because of this one, the duty to orient, educate, and evaluate. So when you're starting off as new nurses, so this goes beyond continuing education department. Nurse managers need to ensure that those they supervise continually provide safe and competent nursing care. We need to remember to respond to any allegations of incompetence or questionable nursing care, implement means of helping staff members gain and the needed skills that they need or education to ensure that they're given that competent care. also to follow up as needed to ensure that the staff member has mastered the skill or has the needed information in order to base their future nursing care. With failure to warn, if the institution has sufficient information and is and suspicion to warrant the discharge of an employee or force a resignation subsequent. I cannot talk anymore. Been too many of these. Let's start over. Let me think. If an institution has sufficient information or suspicion to warrant someone to be let go or discharged or force a resignation, subsequent employers should be advised of those issues. Thank you. Finally got that out. The State Board of Nursing or agency that oversees disciplinary actions of professional and non-professional nursing staff should always be notified whenever there is a cause to dismiss an employee for incompetency or impairment unless the employee voluntarily enters a peer assistance program. Let's say someone was doing drugs and they were caught and they were being let go unless they started into this peer assistance program. If they refuse and they just leave the institution high and dry, forget this, I'm not taking the drug test, whatever it may be, the institution or that nurse supervisor has to report this to the Board of Nursing. Most states now will recognize qualified privilege and allow previous employers to give factual, objective information to future employers. However, that the previous employer must have listed the nurse manager or the institution as a reference before these privileges arises. So you need to check your individual state laws before discussing any kind of qualified privilege. You can't just go out there. They have to call you for a reference first before you can let them know about that employee or that former employee. So we're going to discuss some staffing issues on the next few slides. And there's going to be 3 areas that we're going to consider. Maintaining adequate staff. Well, out on the West Coast in California, they were the first state to adopt legislation that mandated fixed nurse-to-patient ratios, and they passed this legislation in 1999. Usually things start out west and trickle over towards the east. 15 states plus D.C. have passed what they call safe staffing measures rather than mandating ratios. So generally, these safe staffing measures call for a committee to develop, oversee, and evaluate a plan for each specific nursing unit and shift based on patient care needs, appropriate skill mix of the RNs and other nursing personnel, the physical layout of the unit, and national standards or recommendations regarding nursing staffing. So to prevent nurse managers' liability, they must show that sufficient numbers of competent staff were available to meet the nursing needs. You don't want to be on a night shift and have all brand new nurses who only have maybe, on the average 3 to 6 months experience. That would be not good. So when it comes to the guidelines, the nurse manager must do whatever they need to under their control to alleviate circumstances. So the nurse managers have a legal duty to notify the chief operating officer, either directly or indirectly, when understaffing endangers patient welfare. One way to notify the chief operating officer is through formal nursing channels, like notifying the nurse manager's direct supervisor. Upper management must then decide how to alleviate the staffing issues either on a short-term or long-term basis. So sometimes this is where you start seeing when they start bringing in the travel nurses that come in and work for a while because of the low staffing, because it is at a dangerous point. Now, I remember when I was practicing that this was really a big issue, and this is floating staff to alternate units. So nurses should be floated to units as similar to their own unit as possible. So this is going to require the nurse manager to match the nurse's home unit and float unit as much as possible, or consider negotiating with another nurse manager to cross-float a nurse. Hence now we have actually just float nurses, because you would send staff. I remember I was working on acute medical, and I had to go cover in a psych ward, and I had no experience. So that was very uncomfortable for me to go do that. Open communications are important regarding staff limitations and concerns. Again, when I worked on Mother Baby, when we'd have a nurse come from GI or respiratory, the first thing they say, well, I don't do babies and I don't do funduses. So, okay, all right, they told us what they could not do, what their concerns were, and so we took up that responsibility from them. And this would help to alleviate any kind of potential liability. The positive option is to actually cross-train nurses within an institution, so the nurses are familiar with 2 or 3 areas and can competently float these areas that they've been cross-trained in, but they need to go every so many months so they don't lose that skill set and that mindset that they've gained from the other units. And this is what I was talking about earlier about agency and temporary staffing, or float or travel nurses. The use of a temporary or agency personnel is created to increase the liability concerns among nurse managers. So there is an issue, and so they come in, they temporarily work, they're trained, they stay there. These individuals are very knowledgeable, they're very adept to go into new units, and they just pick things up very quickly. They also get paid a higher amount as well. Protective and reporting laws. Usually nurse managers are the ones that are responsible for ensuring that the correct information is reported to the correct agencies to avoid any kind of potential liability against the institution. Many states now have mandatory reporting for incompetent practice is one of those. Reporting incompetent practice often is restricted to issues of chemical abuse, special provisions that prevail if the affected nurse voluntarily undergoes drug diversion or chemical dependency rehab. You also have mandatory reporting of incompetent practitioners. This is actually a very complex process involving both legal and ethical concerns. Nurse managers also must know what the law requires when reporting is mandated, to whom they send the report to, what the individual institution expects of the nurse managers. However, when in doubt, seek clarification from the State Board of Nursing, the hospital administrators, or professional association. Here's a quick overview of informed consent issues. Remember, legal capacity is usually the first requirement and is determined by age and competency. Age is generally 18. Competency involves the ability to understand the consequences of actions or the ability to handle their own personal affairs. State statutes mandate who can serve as the representative of the minor or incompetent adult. There's a list of following types of minors that may be able to give valid informed consent: emancipated minors, minors seeking treatment for substance abuse or communicable diseases, and pregnant minors. Privacy and confidentiality. Again, we're looking at HIPAA, written information not being exposed, papers not being left out, medical records are confidential. A patient does have the right to access their files, medical records, and so again, making sure that you understand the laws in the state that you're in. Incident reports are usually considered internal documents and should not be discoverable upon open for review by the injured party or the attorneys representing the injured party. So it's not open for review for everyone else. It just goes to your institution. In most jurisdictions, this question has been brought up many times. However, the courts have held that the incident report was discoverable and thus open to review by both sides of the suit once there is a lawsuit that goes into action. It is therefore prudent for nurse managers to complete and have staff members complete incident reports as though they will be open records. So you have to think about, okay, once this goes to court, this will be open and there will be others reading this. As I've always said, just the facts, ma'am. It is also inadvisable to make any notation of the incident report in the official patient record because such a notation incorporates the incident report by reference, and there's no way to keep the report from being seen by the injured party or attorneys for the injured party. Here's some information about the American with Disabilities Act, so please look over this information here. OSHA, please read over this. The Family Medical Leave Act, and again, all these are review. You've had these before. And the last one is the Whistleblowers. Essentially, whistleblower laws state that no employer can discharge, threaten, or discriminate against an employee regarding compensation, terms, conditions, locations, or privileges of employment just because the employee in good faith reported or caused to be reported verbally or in writing what the employee had reasonable cause to believe was a violation of a state or federal law, rule, or regulation. Most whistleblowers are internal, that is that they report misconduct to a fellow employee or supervisor within the agency. External whistleblowers are those who report misconduct to outside persons or entities. The cause of action in that lawsuit includes violations of the nurse's rights of free speech and due process, whistleblower retaliation, and interference with their business relationship, specifically with employment status. So, again, many times people are afraid to say anything because they're afraid of losing their job or not getting the raise they were promised or a position, and this is against the law to not allow or to cause someone not to be able to continue with their job just because they reported something that they saw was illegal or something was not good done in good misconduct, whatever it may be. All right, that's all I have. Hopefully we'll have some books here soon.